Hi everyone, thanks for joining. Today we will be talking about GDPR and privacy. If you haven't heard about GDPR, then where have you been? It's been everywhere, all over the news, with things like Cambridge Analytica and Facebook. And it came in May of this year. So before we get going, just a couple of notices. Just to say that nothing we'll say today is legal advice. And if you could save questions till the end, and any extra questions, we will be in backspace for the afternoon coffee break. So I'm Jemilla Olufeko. I'm legal counsel at ROLI.
My name is Iris Brandes. I'm head of legal of Ableton with other legal counsels.
And my name is Philip Lengeling. I work with Rafter Marsh, and we work together with a lot of great music technology companies, also such as Ableton and ROLI. So, to give you a very broad overview of some of the data protection laws, the EU takes a very different approach than the US. So in the EU, we now have this general data protection regulation, which applies directly to all, we're going to get to that later, but to all data controllers who actually process information, personal information of European citizens. And it's all in one very long document. And the US, however, takes a more sectoral approach. So you have more areas in law which give you an overview, which provide laws and regulations of how you process certain types of information in what scenario. For example, COPPA, which is the Children's Online Privacy Protection Act, which governs how you process personal data of children, or HIPAA, which is in the health sector, or FERPA in the education sector. And also you have, for example, the FTC, which is the Federal Trade Commission in the US, and they enforce unfair and deceptive commercial practices, and those were some of those things. You basically have to do what you say you do and not do something different, and that came through, for example, also with Facebook and some other companies. However, now as our field in data protection is kind of developing, also some states, such as California, are developing new laws which also take this omnibus, this collective approach. So California Consumer Privacy Act comes into effect in the beginning of 2020, and that takes more the kind of European approach. And to really sum it up and have a practical tip, when you process data, apply EU standards for customers, which is the higher standard at this moment than the US standard. But when you process personal data of children, take the US standard for COPPA. And for COPPA, we have a quick video from the show called Silicon Valley.
Trust me, just give me 5 minutes. There he is.
Wait, is that our lawyer? I thought he was in jail.
Hey, perfect timing. I just completed the detailing on this Kia. Come on.
What the fuck is going on? Wait, I don't understand. How did Richard have access to our user data? Someone must have let him in. It was you. You're a fucking rat, Jared.
But Richard entered us without consent. In spite of that, he has raised a real issue here.
Fuck this. I'm gonna Uber home. Mr. Monahan, good luck with this whole work release situation, but I have more important things to do.
Mr. Chung-Tai, it appears that 33% of your users are under the age of 13. It's also apparent that you have no parental permission requirements in place. You're going to want to sit down for this. Are you familiar with COPPA?
Who?
It's the Children's Online Privacy and Protection Act.
This act establishes strict guidelines to protect the privacy of younger children on the internet. You are in gross violation of this act.
You know how kids can't have a YouTube or Facebook account till they're 13? It's because of this.
Yes, but our users are chatting with each other, Jared, not some old creep. No offense.
None taken. My shame will linger even after my voting rights are restored. Now, are there records of these chats on your server?
Yeah, we store everything. Okay, what's going on? How serious is this?
Each violation of COPPA carries a penalty of $16,000.
So we're fined $16,000? Oh no. I hope they take cash.
$16,000 per user.
Not only each user, each use.
So 51,000 estimated underage users times an average 25.6 chat sessions per user times $16,000. $21 billion?
Yeah, I have nothing to add to our Silicon Valley-based colleague here. So, what is the GDPR? The purpose is to protect all EU citizens from an invasion of privacy and data breaches in today's data-driven world. As technology developed, we all carry smartphones, which carry so much personal data. That's why the GDPR got created.
Now, it affects all companies with customers in the EEA. Be aware that although it's a EU legislation, it was extended to the European Economic Area. This means if a company resides in one of those countries, 27 EU countries and 4 EEA countries, then the GDPR is applicable, and also for US companies who have customers or address their offering at customers in this European Economic Area, then they are subject to the GDPR and have to comply with the rules and regulations. For simplification, we would just keep on saying EU. You just keep in mind there's 4 more countries. Also, we already heard about fines that are imposed if you violate or infringe COPPA. If you are infringing the GDPR, you can be fined up to 20 million euro or 4% of your global annual turnover, whichever is higher. Of course, not for first-time infringement, this fine won't be imposed on you. However, it's not only the fines. Once you're on the radar of the authorities, they can make your life a little harder or a lot harder, depending on how your cooperation. There can be audits, and they can come at any time. So it's not only the financial aspect, and it's also publicity. I mean, we heard a lot of companies who had data protection or were not compliant to data protection, and this is also an image thing, which might be even harder if your customer reputation is lost due to that.
So drilling down into a bit more detail of the GDPR, we're not going to get too legal on you, don't worry. So some of the jargon, so personal data, we talk about that a lot, but what does it actually mean? It's very broad, so it's any information relating to an identified or identifiable natural person, which we call the data subject. And we also talk about processing, the processing of personal data. So that, again, is a very wide definition. So you can see a long list of nouns there: collection, recording, organization. So any of those relating to personal data, that means you're processing it. But also, just going back to personal data, sometimes anonymous information can become personal data if you have different databases and they can be easily matched together. So, for example, on your API, that could become personal data and then fall underneath this GDPR. So consent. So when you think about processing personal data, this is usually the first way you think to justify it. So under GDPR, it really increased the bar of what consent is. So it's a higher threshold to meet. So now consent has to be freely given, specific, informed, and unambiguous. You also have to keep a record of consent if you, as an organisation, so that you can prove that that person did actually give it to you. It's also got to be easy for your data subject to withdraw their consent, so to say they don't actually consent to the processing of their personal data anymore. And as an organisation, although you are requiring consent from your user, your service can't unreasonably suffer as a result if someone doesn't want to provide their consent. So you probably would have seen earlier on this year lots of emails from retailers, e-commerce companies saying, we don't want to lose you as a customer, please click this link and consent. So that was because lots of organizations didn't allow you to, didn't provide a GDPR compliant way of consenting to marketing emails. So consent is just one way that you can justify processing personal data. There are other ways that are called lawful bases, and the most common ones are on this slide here. So legal obligation, which is, for example, in the EU, you have to, if you have employees in your company, you have to make sure that they have the right to work in this country. So one way to do that is to take scans of their passports, which obviously contain personal data. So that's an example of legal obligation to process personal data. Another example is legitimate interest. So that could be collecting usernames and email addresses. Another example is fulfillment of a contract. So if you are a company that sells products that have to be shipped somewhere, then if someone's paid for that product, you obviously have to have their postal address, which is personal data, in order to fulfill your end of the bargain. And finally, consent, which we've spoken about. But really, one of the main changes that GDPR has brought in is to go away from this automatically thinking about consent being the justification, as it can bring up issues as previously spoken about.
And one of the main subjects of the GDPR is that you need to be transparent about what kind of personal data you process, under what circumstance, and for what reason. And there are several ways of providing your user with such information. And the oldest document most of us know and have seen in many times and accepted and, of course, read the entire thing is the privacy policy. And this really contains exactly all the information under what circumstance the personal data is processed. But even the legislators know that there are many, many people who don't actually read the privacy policies, which I sometimes which I do encourage you sometimes to do, but anyways. There are other ways too, of course, the terms and conditions, but that's just like the privacy policy. But you also, for example, and I'll get to the cookie policy later, you can include such information in your frequently asked questions. Also in your user settings, in any kind of user interface, on your website in a certain column. And this is the part where you can be very creative, because you can invent tools to inform your users about such things. Also note it should be information about cookies you process, because actually there are other local legislations, especially in Europe, who provide you with guidelines and how to inform your users about cookies you use. So you actually have, such as in the UK, you have PECR, P-E-C-R. And here you actually need to gather consent when you place a cookie on someone's computer to remember them for future use or to remember the settings, even, and that's very important to say, even if that cookie or anything else does not collect personal data. So you have separate guidelines for cookies.
So GDPR has increased some of the rights for data subjects. So there's the right to access, the right to be forgotten, the right of data portability.
Yeah. And I think it's more or less self-explanatory. The right to access means you can actually find out about what kind of data has been stored, where, for how long, where from. You also can claim the right to be forgotten, so that your data is being deleted from the system. And also, if you can also ask for your data to be transferred. And a common example is when you change phone providers, then you want to take your phone number, or in most times you would like to keep your phone number, and this is what the right of data portability, or it's just an example. It's also important that you don't have, as somebody processing data or an entity processing data, you have to react with what is called undue delay, and as a rule of thumb, it's up to a month or 4 weeks that you have to react if you get a request by a customer.
And maybe a few practical tips on this one. This is why it's important, if you have personal data, to really understand what you have, who it's from, where it's stored, so that when someone, and it probably is a when, someone comes and asks for these things, that you know exactly where to get them from. And it also brings to light the importance of having a data retention policy, so how long you're actually holding data for, and having sort of policy where you periodically delete the data, because if you don't have it, you can't provide it.
And I always like to provide you with some real examples of how some companies do it. Obviously, some smaller companies just let you know to request it via email. But companies such as Facebook, for example, you can access all that kind of information, and that also brings me back to the transparency requirement in your user settings. So usually you'll find some privacy settings tool, and for example, one of the, the right to access, we have here portrayed in a screenshot, and you can actually scroll down because Facebook, collects much more information than that. And I've circled in red here, you can choose to download your information, and that is really this right to access. And then you have a folder of a few megabytes, and then with links, and you can find your pictures, your posts, your likes, and all that kind of interesting stuff. So I recommend to look at real-life examples, how some of the larger companies do it, if you want to have some guidance or some ideas.
So what Philip was talking about in the example he just showed you from Facebook, the concept is called privacy by design. So this is all about making sure you're including data protection and the concepts of privacy within your systems, your software, from the beginning, rather than as an afterthought or later on in the life cycle of that product. I think it's called technical deficit, where it's a lot easier to, as a developer, to include something at the beginning rather than do it at the end. It takes a lot of time and money.
And what comes with it is the privacy by default principle. It's also if you set up a system that you don't pre-tick boxes where users would have to accept certain things, but it's rather them having to actively tick and consent. This is what the resembling or principle is here.
So what does this actually mean for me? So there are a couple of points that we wanted you to make sure that you remember as takeaway points from our presentation. So privacy by design as the first one, as developers, making sure that you're aware of privacy and data protection from the start. And similarly, keeping track of your data. So again, really understanding, and often, so at ROLI, we did a data audit where we had a look at where all our data was across all of our offerings. And it was not the most fun exercise you'll ever do, but it's really helpful in order to really understand where your data is. Also security, which we haven't really touched upon in too much detail. I've got data on the brain. So it's really important if you have a data breach that you act immediately. You have, in the UK, you have 72 hours to report a data breach that is severe to the ICO, which is the data protection sort of authorities.
Yeah, and if in doubt, speak to either your legal counsel if you are in a company which has a legal counsel, or to a lawyer, of course, right?
Or if you have data protection officers in your company, you can also approach them. So there's also IT specialists specializing in data protection if it's not only the lawyers.
Absolutely, absolutely, yeah. And also, because sometimes it's useful, especially when we speak about privacy by design, to have some great websites. Feel free to take a picture of this. Also, if you reach out to us or to me later, I can also provide you with the PowerPoint here. There are great websites which give you some basic guidelines. For example, the ICO, that's from the UK, one of the data protection authorities, and each EU country actually has one of those. So if there are any Germans in the audience, you can also look up the German one. I see someone. And yeah, they give you great summaries, and you can actually read it even if you're not an attorney. Yeah, and some more links, but yeah. Oh, that one, I hope that one, that's the FAQ by the FTC. That's important if you provide your products in the US, but again, at some point you should speak to a lawyer, perhaps.
Okay, are there any questions from the audience?
Oh, I see someone.
Thank you. Thank you very much. One question about the right to be forgotten. So what is, if you need to keep the data for your bookkeeping, for example, but the user requests to be forgotten? What about these cases? Can you keep the data then on your servers and just don't display them publicly anymore, or how do you treat this?
It's a really good question, and a lot of the technical minds are the ones that ask that, because it's a really difficult concept, forgetting someone or forgetting things or deleting things. But the simple answer is anonymization is the key there, really. So if you can anonymize the data, then it stops being personal data.
Yeah, but if there is a legal requirement, then of course you have to comply to that legal requirement in this regard. Still, it's important to be hygienic about the data and be sure that you only collect the data you are required. So if a person asks and then there's data that is not legally required, of course this data has to, the right to be forgotten applies to that. Whereas for the legal requirements, if you have to keep things for a certain amount of years, this is for tax reasons for instance, then you keep it for that time. After you have fulfilled the tax requirement, then of course you would have to delete that data as well.
Thank you.
Any other questions?
Where does Google Analytics fall into this? Is that considered anonymized enough, or should we be anonymizing on top of that when we're collecting things? And do we definitely need a little tick box saying, hey, collect all my things?
So one major thing with Google Analytics was that there was this transparency requirement missing. So people who were using those games, they did not know that their personal data was being shared amongst others. And one of the big things, which is even from a US perspective, as I spoke about the FTC, there was this consent decree already a few years ago, I think in 2010, about Facebook, that you had to be transparent. I'll give you 1 second. And there you had, so it's one of those transparency requirements. Sorry, what was it?
You're answering about Cambridge Analytics. I'm talking about collecting usage data within your software using Google Analytics.
Oh, Google Analytics. Yeah. I'm sorry.
What kind of permission do we need to use that, and is Google's own anonymizing processes considered enough?
Yeah. That also goes a little bit into, and please feel free to chime in, also into the cookie policies. But again, even there, it's the transparency requirement. So if you embed Google Analytics in your own service, you need to make sure that your user who visits your service or your website or your platform knows that this information will be actually processed with the help of a third party, which is Google Analytics. That's the very broad, quick answer to this.
I totally agree. So Philip mentioned earlier the cookie requirements, which are separate but interlinked with GDPR. From a GDPR perspective, if the information within Google Analytics is genuinely anonymous, and there's no way of you connecting that to a living, breathing human being, then Google Analytics is fine.
Yeah, although it's arguable that there are certain features, at what point can you actually connect it to a personal data, right? If you have some more information, for example, someone always circling, right? Has some tick when they wait for 2 minutes and you start circling, at some point you have that information, you can actually connect it to your colleague or something, right? Or another way of finding this is if it shows what kind of things you click, and then what kind of, even if you have screenshots or something of someone typing in their personal data. So you need to be very aware of what kind of service you're using and what they're actually collecting. So you really need to go into each detail and then disclose that information if necessary through, whatever law which applies, whichever. Yeah.
Thanks. Sorry. About the privacy statements, is there like a legal frame what you can put in there? Because when you said be creative, that means that companies usually put stuff in there that I might not be content with to accept. That's why I should read it. But are there terms that would actually render that invalid anyway, because it would be considered like bad faith, or I don't know the terms that apply there?
So we've got to be very quick with answering this question. I think everything's in the guidance, really. So within the GDPR, there's, in fact, the ICO has a beautiful website that has checklists for things to include within your privacy statement. So long as you've included those, you can have a bit of creative license about how you do, but so long as you've included those, then you should be fine.
And we spoke about the consent requirement, so no surprises allowed. So you don't consent to something if you don't think that's actually in the privacy policy, right? Some had some funny
exactly
inserts.
like suddenly having a sale in a privacy statement that you consented to, or something like weird.
Generally, you can't hide anything in a statement such as that.
That's good to know.
But we're happy to answer more questions later on in the back room. So happy to continue that conversation.
Also, one thing, if you have several documentation or communication on your website, make sure it's the same what you're saying. So having a privacy policy and thinking this is maybe very complicated legal speech, then you have having an FAQ. This should still mean the same. Make sure that it's not the communications subtiling doing the FAQ and the legal department doing the privacy policy, and they contradict each other. This is also a tip about creativity.
Okay, thank you.
Okay, thanks very much, everyone. That's all the time we have now.
Please remember to come if you have further questions at 3:30.
Yeah, in the coffee break, we'll be in Backspace.
And any women who are interested in coming to the women's luncheon, or men who want to support and join us, you are welcome to come to the luncheon, which is right now. And big hand of applause for the panelists, Jemilla, for organizing this. Thank you.